another mess that hopefully is going to be cleaned up by the Supreme Court. I'm not sure what's going to happen for the people who are screwed by it already, but what is the big decision in that new case, Niz or something like that?
Yes, and I gotta keep looking at it to make sure I say the Z not as a V. It's Niz Chavez v. Garland. It was published on last Thursday. It's about non-LPR cancellation of removal and the stop time rule. And, we do these podcast videos with you either on Friday or Saturday usually. And I always give kind of like a teaser to my podcast because I discuss cases here that, I'm going to discuss on Monday on my podcast. But I'm happy to do it. But as I can't help but note, it is kind of funny. This is Justice Gorsuch writing the majority opinion with Justice Barrett and Thomas with him, by the way, which is kind of odd because they joined the historic liberal wing, Justice Breyer, Sotomayor, and Kagan. And Justice Gorsuch is technically ruling against Attorney General Garland by sitting on the seat that should be Attorney General Garland. And he's ruling against Attorney General Garland. But if Garland was on that seat, I bet you Garland would be in the majority, right? The whole thing.
Yeah.
Crazy, right? And I know it. I don't know if you've had a chance to read it, but I've said it before with Justice Gorsuch. I mean, he and I, who am I, right? But he and I probably disagree on a lot of views of what constitutional law should be and all this stuff and interpretation. But he is a great writer, and he is nothing if not consistent. It appears in his textualist, in his textualist view of really every issue. It appears he hasn't been on the bench for that long, but this is a purely textual decision based on the statute's text and really just one word, the word "a," literally, the smallest word in the English language. This is about the stop time rule, non-LPR cancellation of removal to apply to even be potentially eligible for non-LPR cancellation of removal in immigration court. You have to have been continuously physically present in the U.S. for at least 10 years. But commission of an offense or commission of certain criminal offenses or this being served with a notice to appear stops the accrual of continuous physical presence under the law. It's called the stop time rule. So if you're served with an NTA, you can no longer accrue the 10 years. Mm-hmm. The stop time rule says if you're referred to an NTA notice to appear as defined at INA Section 239A. The quote is something like that. The statute is something like that. A notice to appear is defined at Section 239A. And so the argument is if the notice to appear served upon the non-citizen does not comply with all the requirements of INA Section 239A, it does not implicate the stop time rule. Some of those requirements are that the NTA have the date, time, and location of the first hearing in a removal case. Mm-hmm. But, since for 20 years, DHS hasn't been putting that in, really, because it's a bureaucratic nightmare. Only a couple of years ago did DHS and the immigration courts actually link up such that DHS can even see when the open hearings are. Plus, it's a bit weird to have DHS scheduling cases on the court's docket. Whatever.
Yeah.
That is what the statute requires. And 3 years ago in Pereira v. Sessions, an almost unanimous Supreme Court, with only Justice Alito dissenting, said this statute means what it says it means. The stop time rule isn't implicated until a notice to appear is served with all of the information. If you don't serve a compliant NTA, stop time rule doesn't apply, and you keep accruing 10 years. But the board and the circuit said, okay, we hear you. But what happens if you're then served with a notice of hearing a couple of weeks or months afterwards, or years even afterwards? The notice of hearing is always going to have the date and time and location of the hearing. So does that satisfy the stop time rule? And the circuit's kind of split on that, whether a non-compliant NTA plus a compliant notice of hearing, which is a totally different document, as you know, can implicate the stop time rule. The circuit's split. The BIA, I'm sorry, go on.
Yeah. I was going to say the BIA as well.
The BIA went in bonk and issued a garbage decision, which quite frankly offended me as a lawyer. Whatever. Reasonable minds can disagree, and the circuits clearly did too. But the way the BIA did it in the Mendoza and 3 other names, Matter of Mendoza, lots of other things case. I'm sorry, I can't not. Matter of Mendoza, Hernandez, and Capula Cortez. the way the BIA and Bank majority said it, they relied on all pre-Pereira decisions. Like, you can't rely on pre-Pereira decisions to decide what Pereira now requires, but whatever. And Bank, the BIA was almost 50-50 split, but of course not 50-50. Ruled that the two-step process will satisfy it. And here, with Niv Chavez v. Garland, Supreme Court saying, no, we meant what we said. The stop time rule only applies with a compliant notice to appear. So all of the circuits plus the BIA who said that it is satisfied by a notice of hearing are wrong. And in so ruling, the Supreme Court didn't even cite the matter of Mendoza-Hernandez, which I find amusing. Because it's statutory interpretation, there would be no reason really to cite to the board or any of the circuits finding otherwise. It's the Supreme Court's decision on what the statute means. And it really came down to what Justice Gorsuch said, the letter A meant. The statute, the stop time rule, refers to a notice to appear, dumbing down his rationale. But that a notice to appear means a notice to appear. It doesn't mean a second document. Mm-hmm. So that's great. It's great for cancellation of removal seekers currently in removal proceedings. And there's just some really, really fun language in here with Justice Gorsuch kind of knocking the government over the head. That is just kind of enjoyable to read as an immigration attorney. He's essentially saying the government is saying that it's really hard for it to comply with forms. And, the government makes people comply with forms all the time. And Justice Gorsuch goes on to say, if a non-citizen does not correctly fill out an I-589, they get deported maybe. So it's not so much to ask the government to also comply with the statute and with its forms when it starts removal proceedings. So that's a little shot in Freude, I guess. It's enjoyable to read as an immigration attorney.